Hi all, welcome to our webinar today. It's titled Register of Overseas Entities. My name is Ravi Viramal and I'm your host for today. Please note the webinar will be recorded and it will be sent to you and you should receive it in the next few days. The seminar will be presented by my colleague Stuart Stobie and Josephine Rocker of Sovereign Corporate and Trust Services based in the UK. Stuart, Joe, you might want to say hi.
Yes, hi, good morning.
Good. The seminar will last approximately 30 minutes and will be followed by a Q&A session. We'll endeavor to have all the questions and obviously have them answered as well in case we run out of time. You will be sent our details and we'll get back to you privately on the questions that you sent us. So we'll get started. Over to you, Stu and Joe.
Thank you, Ravi, and good morning, everybody, and thank you for taking time out on a Wednesday morning to listen to this subject, though it is obviously, we are talking about a compliance subject, so unfortunately it's not going to be particularly exciting, but it is also very necessary subject to cover due to the various sanctions that are in place if you don't get this done sooner rather than later. I'm just flanneling a little bit because I'm noticing that we're still receiving attendees, so I might just wait for another sort of 30 seconds or a minute or so. So I do apologise for all of you who are online already, and thank you very much indeed for joining us. I think we're sort of starting out now, so I'll go on this one. Basically, as this particular piece of legislation, which was enacted, was basically brought in. It had been talked about for a while. Basically, I think there was a lot of press about who owned what, particularly what properties and land was owned by various overseas entities and who was behind those entities. And there's been a lot of talk about making that more transparent for a long time. But what the initiative that actually brought this into being was, I think you're probably all aware, was that when Russia invaded Ukraine and a lot of the oligarchs, etc., and other Russians were put on a sanction list, and people wanted to see who was behind, excuse me, was behind those entities owning various pieces of real estate within the UK. So that's where it came from, and hence the sort of title of the legislation, the Economic Crime and Transparency Enforcement Act. In terms of the process, who is actually responsible for running this, that's Companies House, and they look after that. And actually, we've had a very good experience with Companies House. They seem to be whoever's actually running that particular team is doing a very good job. We have a great interaction with them because, as you can imagine, most of the entities we register there are very straightforward. One or two shareholders. And just an offshore entity, but with some of the structures, on the other hand, are far more complex, and the Companies House have been very helpful. And in terms of their response times, in terms of filing and issuing registered numbers, again, they've been fairly quick. We've seen a slight slowdown, but it's probably taking about a week from start to finish from filing. From verification and registration to getting an overseas entity identification number. So that's the issue. In terms of that's the ministry, and that's the piece of legislation behind this all. It's been rushed through the legislation, and the company regulations are not succinct or clear, so there is still some confusion. Again, I feel for the people at Companies House who have to deal with our various questions on this matter, but they've done a pretty good job to date. But again, you'll hear all sorts of variations on what has to be filed and when to be filed, and we're still getting legal opinion in some points, so there's still some clarifications. So you might, if you ever approach us to ask us to register, you might, with a complex structure, that you might get different answers depending on who you're talking to within the sovereign or external. So just be aware of that. As you can see, it applies to various, depending on where the property is owned or the land is owned. And I'll just, rather than referring to property and land going forward, I refer to real estate, just a combination of the two. As it says there, if the property or the real estate, sorry, was bought after 1st January 1999 in England and Wales, you need to register 8th December 2014 in Scotland, and for that UK real estate in Northern Ireland, Northern Ireland real estate, in other words, it's anything owned acquired after the 1st of August 2022. So it varies on which particular country within the United Kingdom you're dealing with, where that property is located. It does depend on the date. Now, just while I'm on that particular subject, if you then want to sell that particular property or that piece of real estate, you will still, doesn't matter if you were registered way back in the 80s, you'll still need to then go ahead and register before the land registry, UK land registry, will actually transact that any change in ownership. And we have seen scenarios where banks have been refinancing properties and have insisted that where there's an overseas entity involved, that it does go and get itself registered anyway, even if it doesn't have to, according to the law or according to the regulations that this particular act has brought into being. So I'll move on. And sorry, I've got ahead of myself slightly there, because obviously that point I've just mentioned is previous on the previous info, when I was still on the previous slide, is mentioned in that first point. So just to reiterate, basically, if you've got a client who's looking to transact using an overseas entity, whether it's buying or selling, they will need to get that registered on the Register of Overseas Entities, which is, as I said, is administered by Companies House. It is something to be paid attention to. Basically, if you're involved in, I think probably most people who have overseas entities, this will impact in some way or other. So it is definitely worthwhile looking at your files to make sure what companies you've got owning overseas entities, because even if you think they may not, and you don't file by the 31st of January 2023, I will come on to the sanctions issues, but there are some major sanctions for not doing so. And also, obviously, as I stated previously, if your clients are wanting to transact with that particular piece of property, then they need to file anyway and get a get a registration number. Right, as I mentioned previously, there is the overseas. There are some pretty major sanctions which are imposed on entities that do not file on time. As you can see from that first point, you need to, any entity, trust, pension, or a company which is overseas owning UK real estate must file by the 31st of January 2023. And if you don't, if that entity doesn't, then and fail to register anything at all, then they are committing a criminal offence. And and unfortunately, again, the regulation's rather wide in that who gets caught in that regard. Because you might think, well, we're not directors of the company; it falls on them. Well, it just basically says any officers, and it doesn't actually state clearly who any officers are. So basically, if you're involved in administering a company, even though you're not directors and nothing's been filed, then you could be caught by this. So, but at the very least, clients need to be warned that if that entity has not filed on the Register of Overseas Entity administered by Companies House by the end of January 2023, so which is looming very fast, excuse me, then you're facing criminal sanctions. And just to add to the joy of this particular on this Wednesday morning in terms of this particular act and its regulations, there are severe financial penalties as well for non-compliance, and the financial sanctions start at £2,500 per day, and so obviously that would build up rather rapidly, so again we suggest compliance sooner rather than later. And as I said, though Companies House is dealing with this right now, there's a statistic which is I've just seen the other day saying that only 7% of, I think there's almost 100,000 legal entities, overseas entities owning real estate in the UK right now, and only 7% of those have filed at this particular point. And therefore there is going to be a tidal wave of applications going in between now and the end of January, and I imagine January is just going to be chaos. Therefore, the emphasis again here is get filings done now, get the company registered, and get the OEIC number issued, because we've all, I don't know, many of us have dealt with UK government systems. All of this is done online. For the most part, this is done online, and there's, I mean, my colleague Josephine will step in a second and explain which one is not done online. So you need to get this done, because there's going to be a lot of filings happening in January, because obviously that 7% is a minute figure out of the almost 100,000 legal entities that should be filing, and therefore whether the Companies House can cope is another question. We're just cracking on with it right now. Moving on to the next slide. Obviously the thrust of this particular piece of legislation is to find out who is behind the various entities owning real estate here in the UK, and so it is a public register, so anybody and everybody can go online and look at the information. Now, there's in regards to trusts, there is not the information on the trusts in terms of set clause, in terms of protectors, in terms of beneficiaries, and any other interested parties. That is not published, though it is available to other UK government agencies, and we know for a fact, and HMRC have made announcements on this, that they have set up a team to go and look at what's been filed on the Register of Overseas Entities, and that they will be digging around for any non-compliance. So again, another opportunity to ensure that any legal entity owning UK real estate is in compliance with the UK tax regulations, because HMRC are actively taking a look at this. But coming back to entities which are owned by trusts, basically all you can see on the public register is the name of the trustee, and you can't even see the name of the trust. But you are still required to file information on settlers, beneficiaries, other interested parties. And I kid you not, this goes into, considering the year we're in, you think it'd be a little bit more sophisticated than this, but it goes into a Excel spreadsheet, which is then that's filed with Companies House, but is not accessible. Just to reiterate, is not accessible to the public, but is accessible, as I said, to the likes of the HMRC. So there is still a certain amount of confidentiality when it comes to trusts. But again, you are still having to hand this information on how that trust is structured to Companies House, and also therefore allowing them to check on any sanction lists for anybody that may be linked to that particular trust that which would raise a red flag. But you can give your client some sort of level of confidence and comfort that the workings of their trusts are not going to be exposed for everybody to see. In terms of the who has to file and when they have to, well, we've done when and we've done who. Sorry, now we're doing who. Basic rule of thumb is that any shareholder owning 25% of shares in an overseas entity or has 25% of the voting rights of those of the shares in an overseas entity, information on them, so registrable beneficial owners, as it's named under this particular regulation, or I will call them RBOs because it's a mouthful. They're required to have information on them filed on the register of overseas, on the register of overseas entities. And again, as you can see from points 3 and 4, basically rule of thumb is if any shareholder or person has any particular influence over the company, particularly where they have a right to remove boards of directors or exercise significant influence or control over that particular overseas entity, then their details need to be filed on the register of overseas entities. So you have to be, so it's quite again, the net is spread quite wide in terms of, it's not just a simple, you own 25% of the shares or you have 25% of the voting rights. So it is slightly wider than that. So beware, again, your automatic thinking is, well, if he's got 25% of the shares, yes, he's a beneficial owner. If he has some sort of protector rights, do we need to report that information? Well, yes, you do. So there's it's quite a wide. It does catch quite a few people. Similarly, trust and pensions, in terms of that particular 25% figure, does not vary. Again, it's the same sort of rule applies, where the if the trust or the pension or the pension trustee directly or indirectly holds more than 25% or has voting rights 25% plus, then details need to be filed on that trust and pensions. But as I said before, what is public is limited. And again, it again comes back to these points about how much influence and control a trust or pension has over an entity, depending on whether you have to file or not. In terms of these last two slides over who has to file, I am simplifying somewhat. There is, as you're all well aware, there are many different variations of a way an entity or an asset can be owned, but this is basically the rule of thumb to start with. But if again, we would encourage people to talk to us. Excuse me. To talk to us if they're unsure on whether a particular beneficial owner is required to be registered and therefore deemed an RBO, because because again the regulations are wide and they're not exactly clearly defined in all cases. We keep asking for I know STEP and various other people are asking for clarification those haven't been forthcoming. So yeah, just be aware that though you think you may look at somebody and say, well, they don't have the requisite sort of equity or whatever it may be, you should be aware that that they might be. So just always best to run that past us. We're always happy to help where possible. Right, my colleague Josephine, she heads up the team, is responsible for looking after our clients who are required to be registered on the registered overseas entities. There are, so she's at the coalface on this. So rather than, and I've got this wrong in the past in terms of the variations on registration process. So rather than me complicate the matter, I'll just quickly hand over to Josephine for her to clarify what the registration process is and give you a little bit of an insight. So Josephine.
Thank you very much, Stuart. In a nutshell, really, the registration process is it's up to the overseas entity to actually declare its registrable beneficial owners, or RBOs. The purpose of an assured agent, which is what Sovereign Corporate and Trustee Services, or SCATS for short, is actually an assured agent, is for people who rely on the register at Companies House to make sure that that information is true and proper and can be relied on. So, you know, banks or any other third parties that need information on a company and now on an overseas entity can go onto the Companies House website and see that that information is there and it's been registered by a company that is an assured agent of Companies House. So that's basically what the purpose of the register or the assured agent is. So the assured agent has got to be UK based. We've passed the HMRC fit and proper test for AML purposes, so we slotted into that category rather nicely. And then we went through the approval process by Companies House to become an assured agent, and we've also got our assured agent's registration number. So essentially that means if there are any queries on any registration or verification of RBOs, then Companies House, the registrar or HMRC, can come straight to SCATS and ask us to clarify if they have any queries. So can you move that slide on, please, Stu? I think there's another one next. Is that for me? Yeah. Yes. So what I'll do, actually, that's going a bit far forward. But if you want us to register and also verify the information about the overseas entity, we're more than happy to do that. So what you need to submit really is the information on your ultimate beneficial owners. And Stu's already gone through the criteria that have got to be met on how you determine what they fall into, either shareholders or significant control. We have an application form, which again, I can talk you through, and I can talk you through certain scenarios if your structures may be a little bit complex. So yeah, you can just contact us and let us know if we can be of further assistance as far as is concerned. But once we've done the verification and we're happy that your structure is what you say it is, or the overseas entity says what it is, we then go ahead and do the registration. And then if Companies House are happy with our submissions, then they will issue the overseas ID number. If there are any disposals, if there's a property or a qualifying estate has been sold after the 28th of February this year, the overseas entity has got to go through that registration process. And it's not just disposals as well. Sometimes, as I think Stu's already alluded to, if there's any charges or any refinancing mortgages that the overseas entity wants to go through, then because there is an annotation on the title at land registry, then the overseas entity will need to register. So there are several reasons for registration, not just the initial one that's got to be done, as we've already said, by the end of January next year, but also ongoing transactions, refinancing, that the third party and the lenders especially cannot proceed without the overseas entity being registered.
I'll just move on to ongoing processes. As Joe has alluded to, there is a requirement to file on the Register of Overseas entities every year. As you can see, I've asked Joe, is this correct? And actually, that's not correct. It's actually
no, it's not.
I do apologise. So that's why I've left that slide in. So filings on the Register of Overseas entities must be verified annually. So that has to be done by the assured agent, and which, as Joe says, we are one. Also, you have not 30 days but 14 days
That's right.
to make it to file any changes to the management ownerships of the overseas entities. And so that must be filed within 14 days. I do apologise for that slide. That was a question for Joe, which I should have clarified. So there's a ongoing need to not only to file on the Register of Overseas Entities, but and that has to be verified by us or by another assured agent. But also any changes that happen in the management or ownership has to be filed within 14 days. Again, sanctions then will apply if you don't do that. So just to quickly summarise the few points on this. You've got until the 31st of January 2023 to file on this. We know that their representations have been made to government to potentially extend that filing, that deadline of filing by the 31st of January. We have heard nothing to suggest that deadline is going to shift. So you need to file because, as you saw from the sanctions, it's not only financial, which is substantial at £2,500 a day. It is also there's criminal sanctions which could catch not only the directors but anybody else basically involved in running their company. Now, one of the things we've come across is whereby a company where you as a, say for example, a client service provider is pretty sure that a company that was put together incorporated 10 plus years ago, owning property in the UK, I'm pretty sure that that's been restructured, but they can't get the clients to confirm that. They haven't got up-to-date KYC on that the beneficial owners involved in that company or anybody else. So the question is, well, I can't file this information because I'm pretty sure it's not accurate. Now, there are various, well, you do need to file. Basically, you have to file, and there are various statements you can make saying, look, here I'm filing with the information I have. To the best of my knowledge, this is how it was structured, but we're not completely convinced, basically, and we are seeking to make contact with the clients, the beneficial owners, etc., to verify whether there have been any changes. But in the meantime, this is us filing. So you can't. There is no excuse not to file. You have to file, even if you're convinced that the structure of the company has probably changed. If you've got sort of people who have now, you might have passed on, for example, even if you're pretty sure of that, but you haven't got confirmation for the clients, that you need to file by the 31st of January. There's no excuse not to, and there are various statements you can make in that regard. So just please bear that in mind, that not having a complete file to register is no excuse not to register. And then if you don't, obviously the sanctions come into play. There's been another question, I know, from I think the Isle of Man government made representations on behalf of the federation that represents CSPs on the island, about why there is a need to have a UK-based assured agent. Basically, to be blunt, it's because the Companies House and the other government agencies want to be able to knock on somebody's door in the UK if they think that the information is incorrect. Now, so there's quite a lot of onus on us as an assured agent to check the information you're giving us is as up to date as possible, and we can verify that it's all up to date and that the company is in good standing and this is the latest KYC. So again, as a consequence of the onus on us to do that, again, there is paperwork we require. It's not a simple case of going, there's a company, it needs to file because it owns property. There is the issue to you need to start work now because you need to provide us with up-to-date information, which is therefore a paperwork gathering information exercise, which, as you well know, involves getting information off clients, and as we all know, that sometimes takes a bit longer than anticipated. And as I say, the 31st of January 2023 is looming fast. So coming back to the point about the assured agent, it is, it's just because you can see a lot of this going on within the UK, particularly Companies House. They want to have somebody here in the UK who is responsible for verifying it and has certain amount of liabilities placed on them. So we have certain amounts of liabilities placed on us to make sure the information we're filing is correct. And so I think there's no movement at all, and I'm really surprised if there was any movement at all on that particular point, that to allow overseas agents to become assured agents. Companies House, it's going to have to, unfortunately, to go through people such as ourselves, but obviously we're happy to assist. I will close it there. I think we're just a couple of minutes over. I'd like to thank you for listening, but at the same time, if you have any questions, please ask them, and we'll be happy to answer to our best of our abilities. If we can't, then again, as Joe has said, and I've said previously, we're more than happy to jump on calls with you guys and have any conversation that would be deemed fit. So, Ravi, I will pass back to you.
Fantastic. Thanks a lot, Stuart. Thanks a lot, Joe. We have got a couple of questions. I've got some myself, but I'll field the first ones from the audience. First question: if the company is under trust, is the trust reportable?
Yeah. So if the company is obviously reportable, and the information on that, and then obviously we need to know who effectively is the beneficial owner of that company, and the information in that regard. Yes, the trust is, but all we have to show, all that is public, is the name of the trustee. In terms of, if you remember, I referenced the use of an Excel spreadsheet to fill in details on beneficiaries, protectors, etc. That piece of information has to be filed, but is not public. But yes, it does. So you do, where trusts are effectively the beneficial owners of legal entities owning properties in this country. Yes, information has to be filed, but only some of it is public. Most of the key points are kept confidential.
Okay, fantastic. Thanks, Stu. Another question. What is the position where there is more than one class of shares? do you need to hold more than 25% of the total shares or voting rights of any share class, or does it have to be of the total shares altogether? And if it is each share class, are you able to highlight this detail in your report?
Right. Okay. I mean, again, comes back to if say, depending on the powers allotted to each share type, it depends on whether they have to be registered as beneficial owners. But say, for example, you have certain share, yeah, you do look at the overall share capital, and Joe, jump in here if you've got any thoughts on this. But I mean, basically, if you've got this 25% plus, and with voting rights, but even if you've got non-voting rights, that you would still have to, and you've got 25% of that of the capital through owning non-voting shares, you'd still have to file, or information would still have to be filed on you as a registrable beneficial owner, because you have equity in excess of 25% of the share capital in that particular company. Whether you have voting rights or not, it doesn't matter. You still have to file. Joe, am I correct in saying that?
Yeah, essentially, if you've got ordinary voting shares, then you're going to probably fit, 4 of the conditions. More than 25%, you've got voting rights, you've got significant control, and you can remove and appoint the board of directors. You might have participating shares or redeemable preference shares that entitle you to, participate in the profits of the company, but you've got actual no voting rights. However, some of those shares will, bestow certain powers on those shareholders. So if you've got a client who, holds these participating shares and rings you up and says, I want you to do X, Y, and Z with the company, do you actually take that as an instruction? Do they have significant control? So it's would you take instructions from these individuals? If it's no, then they probably won't have significant control. However, they still might be registrable because they own more than 25%, irrespective of whether they're ordinary voting shares, participating shares, or whatever.
Thanks, Joe.
Okay. Thanks, Joe. I hope that's answered that question. I know some of them can get quite technical, like that previous one I just mentioned.
I mean, as I think, Ravi, as I think I mentioned before, is that there's so many variables involved in this that basically as I said previously, it's sometimes better just to sit down and run through the who owns what and how with us, and then we can thrash it out. But it unfortunately, again, the regulations that come out of this act are not always very helpful in clarifying what needs to be registered and what doesn't. So we're always happy to work through a particular entity with somebody at any given time.
Yeah, excellent. Thanks, Joe. A few practical questions from my side. How long is the registration and verification process?
We are currently, and I'm jumping in. Joe can slap me down if I get this wrong, but it's because he does this day to day. But we're basically from receipt of all the required information. So to that being submitted being verified and registered, and then the company's house issuing an overseas entity's ID number. We're looking still about 5 days, Joe, is that correct?
Well, at the moment, when I've done the registration, if they've confirmed a receipt or the receipt, the submission, they're still putting 2 working days on their emails.
Yeah.
So it's still quite a good turnaround.
Yeah, so I would work in theory on the fact that from us receiving everything we require to and getting everything into company's house and they're issuing it, you're looking at 5 days. Now, as I mentioned before, there is only 7% of the entities who should be registering, which are required to register, which have done so, and therefore, that right now the workload in the company's house is relatively light. It is obviously going to increase So get moving fast, basically, is the message, because you don't want to be caught up in, when they've got so many to review. And they do review, they actively do review. So don't think it's just sort of a tick box procedure on their part. They do. We have seen situations where, like say with the limited partnerships, where they've picked up on the fact that basically information is wrong. So it's not just, press a button, submit, and it all goes through a process. They are actively reviewing these things. So obviously, with the as the increase of fines happens, there will be a slowdown. So again, emphasis on move now and get things filed as soon as possible.
Okay. Another practical question from my side. What if there's not complete due diligence on the beneficial owner?
Yeah, again, and if it's you have the deadline of 31st January file, and you basically file with what you have, with a statement saying we haven't got complete KYC. So we have, right now we're not coming across those because we've that many, because we've still got time. But obviously, as we push up against the deadline, there's going to be more and more of these. Because also at the same time, something I don't think I emphasize is that you've obviously got to approach the clients to tell them what you're doing on behalf of the company. So you need to make a statement to them saying, look, we're going to have, under the law of the land, we're going to have to disclose information to the Register of Overseas Entities about you. And so there's that process. And then hopefully that starts the process of gathering KYC. Again, as I said previously, if you do not have what you think is a complete file, you still need to do so still need to file by the 31st January with a statement saying we accept the fact that the KYC is complete, but that acknowledged, and then you are required, again, the onus again is on the managers of the company to go out and make sure that they get that up-to-date KYC, and then make necessary amendments by filing amendments to that initial registration. But basically, there is no excuse not to file before the end of play on the 31st of January 2023.
Yeah, and any updates, there's a duty to update that comes into force on the 16th of January next year. So as you say, Ravi, if you haven't got the complete due diligence when you actually get it, then you have that updating duty that's got to be done within 14 days.
Okay. I've got a question from the audience, which is sort of on the similar lines or similar subject. Do beneficial owners have to check the information that is being submitted?
There is there's the statutory notice that you've already mentioned, that you have to tell your UBOs that you are going to make this declaration, because there is a statutory obligation to do so, and you tell them the information that they've got, that you have, that you're holding on those individuals, and you give them an opportunity within 30 days to come back and say to you, yes, that's absolutely fine, nothing's changed, or there have been changes. So there are 30 days. If they don't come back within 30 days, then, as we've already said, you file with what you have. And then when you do get the updates, then you've got a duty to update within 14 days.
Okay.
So basically, you have to, as Joe says, you have to inform the clients what you're doing, but in terms of what's being filed, no, they don't. You don't have to then go back and say, look, this is what we're filing. You might just, in terms of client relationships, you might want to do so, but no, there's no legal requirement to do so.
Okay, thanks for that. I've got quite a few questions over here. I'm conscious we've got limited time. If it's okay with you, I'll carry on with some of them.
Yeah, sure, please.
Stop. Yeah. Okay.
Yeah.
Great. So, does information on beneficiaries that have not received benefit need to be filed if the trust is fully discretionary?
Yes.
Yeah, it's actually whether they've received dividends or distributions is irrelevant. If they're a discretionary beneficiary, then that information is disclosed on the Excel sheet, and as Stu's already said, it's uploaded to Companies House, but it's not public information. but the information is available to the authorities.
Okay, thanks. Next question. If the property was transferred by the same UBO within companies, are both companies to be reported? I'm assuming it's transferring from one company to another. Do both companies need to?
Yeah, Ravi. This particular piece of legislation covers that tells you that they know what entities own which properties. It's the whole driver behind this is knowing who is behind each entity. So it doesn't matter if there's a UBO owning 1 or 20 companies owning UK real estate, all those entities will need to be registered. It doesn't matter if the UBO is the same. Every single legal entity has to be registered.
Okay, thanks, clear. If a corporate trustee holds first charge on a property, do they need to register only if the property is going to be sold?
If a trustee simply has a charge over a property, doesn't have legal title to that property, the understanding is that there is no requirement for that trust to file. Again, coming back to my point, this is what they're looking at is the legal entities that actually own and have title to the properties, the real estate in the UK. So if it's simply a trust placing a charge and that charge is registered at the land registry, there is the register of overseas entities does not catch that particular arrangement.
Okay, thanks, Stuart. Another question. If a company becomes an owner of a property before the applicable date and it was to sell the property now in 2020 to a UK resident company, is verification and registration required?
Yes, unfortunately so. Again, if you're basically saying if it say bought it back in 1990 and then sold it now, yeah, unfortunately it would have to register on the Register of Overseas Entities, even though it predates the dates laid out in the regulation in the Act, sorry, about what entities have to file. But as soon as, so even if it predates those dates, no, while it's simply holding on to that property, no, it doesn't have to file. As soon as it wants to transact on that property, in this case sell to another entity, it has to file on the Register of Overseas Entities. Otherwise, Land Registry will not accept that the change in title.
I think also what we need to mention as well is that the Act actually provides for Land Registry to put a limitation on the title deeds, an actual restriction. So Land Registry are doing that already with all title deeds that are held in the name of overseas entities. So as Stu's just said, even if the company bought the date before the statutory date that's in the Act, when it comes to sell, it must register. Otherwise, the title deed will not permit the land to be sold because it's got a restriction in the title deed. So be aware of that.
I think also just while we're on that particular point in terms of the Land Registry blocking any transactions, you've got to remember this coming back to the sanction issue as well. People say, well, I'm overseas, what are they going to do to me if I don't file on time? Well, obviously there's a fixed asset here in the UK, which the Land Registry will just you won't be able to touch if you haven't settled, if you haven't filed on time. And there's sanctions against you. There's obviously the Land Registry has, and also HMRC and Country's House itself and any other government agency has rights to put charges over that property to ensure the enforcement of those sanctions. So again, it's the emphasis again that you've got a UK citus asset here involved, and therefore if you don't comply with these regulations, then they will find a way of extracting their pound of flesh in the form of the fines, and also in terms of applying criminal charges, and also just blocking any sort of transfer of that property, sale of that property, or transaction on that property, or even refinancing on that property. So it's serious stuff. It has to be full compliance is necessary.
Okay. Following question: if a property is owned by 5 companies, each with 20% shareholding, for example, does each company need to register?
So sorry, if 5 companies own one property, is that what the question is?
Yes.
No, again, it's more. The 25% rule applies to how the ownership of the company is. If there's a company owning UK real estate in any form, it needs to file.
Okay.
That will be my understanding.
Sorry, I should have made it clear that there's one beneficial owner that owns this one property, and it's done through 5 companies.
Yeah, it's all 5. In my view, and Joe, you might want to jump in, but my view is why. Anyway, they are looking, any legal entity owning title to property in any form needs to register. Though on that particular point, because of the way it's structured, which is this is the first time that's a new one. I might want to clarify that point. So whoever's asked that question, please make contact with me. But I would, the fact that what the driver of this legislation, and though it's not the best drafted piece of legislation in the world, is to find out who's behind any legal entity. My initial thought would be that there would be a requirement to file and register every single one of those legal entities. But I would like to clarify that. But I would assume, you would have to file. But again, whoever's asked that question, please make contact with us, because that's a new one on us, to be honest.
Okay. Yeah, I thought so. Following question by the same person. A UBO owns a holding company that in turn owns other companies that own UK real estate. So
yeah, I'd like to see a structure chart, because we need to know the percentage of the holdings, whether that brings it in scope or out of scope of registration.
Well, the question was, does the holdco have to, that does not own any property, does that have to file anything?
Well, it depends on the percentage of shareholding. So I'd like to see a structure chart, and obviously the percentage of shares, and then we can determine whether it's in scope or not of the requirement to register.
Are you saying, Ravi, there's a holdco owning a legal entity that owns the property?
Yep, that's what it sounds like. So a holdco that owns other companies, that owns UK real estate, does the holdco need to file?
Well, if it's owning those legal entities outright, then yes.
Okay. I assume that's what they mean, but we can obviously get back to the person who posted that question.
I think whoever this person is, I'd love to have I think there's all sorts of interesting conversation we have had on this subject.
Absolutely. Another question, is there a difference between discretionary beneficiaries, who are named individuals, and those who form part of a wider class, e.g., for example, children and remote issuer of shares?
No, on the Excel spreadsheet, you would either declare the individual beneficiaries, or you would declare that there is a class of beneficiaries.
Without having to name or everybody in that class. Correct.
Yeah, you couldn't possibly, because as you say, if employees or wider issue, you go on and on and on. So you just say it's a class of beneficiaries.
Yeah.
Okay. Excellent. There was a following question from another individual, and you seem to have answered that. But their question was, do you disclose named beneficiaries only or class of beneficiaries? So you seem to have answered that.
Yeah.
Okay.
Correct.
Okay. Excellent. We're doing quite well. I've got there are a few more questions. I'm conscious, obviously, of time and so forth. So I'll ask one more. And as I mentioned, and we all have stated, we'll get back to those who have posted the questions. If the company is going through a striking off process, do they need to register?
So that legal entity is being struck off, but it still owns a property in the UK. I would argue, well, you need to get that property moved anyway, because you're going to lose the legal entity that's going to own it. So yes, it does.
Yes is the short answer. Yeah.
Yeah.
Yes.
Yeah.
It doesn't say if the company owns the property, but I assume so. But okay, thanks for answering that. Fantastic. That wraps up our webinar presentation. Thanks a lot, Stuart. Thanks a lot, Josephine. I hope those who attended have found it very useful. As I mentioned at the top of the presentation, we'll be sending out recordings of this to all those who have attended. And those who have posted questions will also be in touch as well. As Stuart and Joe mentioned, some of these can get rather technical, and further clarification is probably needed. Stuart and Joe have the resources in the UK, so they can be able to assist with that.
Thank you very much to everyone who's taken time to listen. It's much appreciated. As to reiterate what Rob says, please feel free to send your questions our way, and we'll be more than happy to answer where we can. Have a lovely day.
Fantastic.
Thank you. Bye-bye.
Bye, everyone.